The content you're about to hear may be graphic in nature. Listener discretion is advised. This is True Crime XS.
This case sort of predates even like the registration of innocence. When you go and look it up, it's an interesting case out of Florida. I was able to pull together multiple different sources in this case. Had you heard of this one before? Because it might have come up in terms of like hitchhiking cases that we had talked about.
I don't think so. There's an element that comes up that made me think twice about it, but I don't think so.
Okay. If you go looking for this case in terms of the names that we're going to use, you may not find it like right off the cuff. I noticed that the original charged perpetrator here is like the name changes depending on where you read about him. This case does not wrap up that I can see. But the person that you're looking for here in terms of the wrongfully convicted person is a guy named Delbert Lee Tibbs. Delbert Lee Tibbs was born in 1939 in Shelby, Mississippi. When he was 12 years old, his family moved up to Chicago. This was a part of something that was known as the Great Migration. Are you familiar with this concept in history?
Yes.
The Great Migration, for audience folks who might be interested in it, it's sometimes known as the Great Northern Migration or the Northward Migration or the Black Migration. This was a movement where over a period of about 50 years, roughly 6 to 6.5 million African Americans moved out of the rural southern United States, and they headed more towards the Northeast, the Midwest, and the West. This was substantially due to poor economic and social conditions. And that was brought about by prevalent racial segregation and discrimination in the southern states where what's known as Jim Crow laws had been upheld. One of the biggest driving forces of the Great Migration, which has a lot of irony with what we're talking about today, was that lynchings continued to be a thing in the United States. Delbert's family is a part of that migration, and they moved north as well. From 1970 to 1972, Delbert goes to the Chicago Theological Seminary, or CTS. It is a Christian ecumenical American seminary. It's located in Chicago, Illinois, and it's one of a group of seminaries that are historically associated with the United Church of Christ. Now, he does not have a particularly interesting life up to the point that we meet him. In 1974, in Florida, there is an interesting crime that occurs. A 27-year-old man and a 17-year-old woman are hitchhiking when, according to the young woman who survives what we're about to talk about, they're picked up by an African-American man who ends up shooting her boyfriend and killing him, raping her, and leaving her for dead on the side of a secluded road. A few days later, 220 miles north of the area that they were in, which was Fort Myers, Florida, Delbert Tibbs is stopped by police, and he's hitchhiking. He's questioned about the crime, and he's photographed. He did not fit the original eyewitness description, so even though he's been photographed and talked to, he's released. That photograph makes its way to Fort Myers, Florida, to the local authorities, and the female victim in that case identifies him. So a warrant is issued. And 2 weeks later in Mississippi, Delbert Tibbs is arrested. He waives his extradition over to Florida. And even though he does not match the original description that the female victim had provided, and for the crime in question and the timeline of it, he had a solid alibi, he is indicted. At trial, in addition to the testimony of the young woman who survived, the prosecution also presented the testimony of a jailhouse informant. And they claimed, like all jailhouse informants claim, that Delbert Tibbs had confessed to this crime. So it's Florida. It is 19 1974. It's going to be an all-white jury. This all-white jury is going to convict Delbert Tibbs of rape and murder, and they're going to sentence him to death. This is, sadly, a sort of common story. Have you ever heard of the play The Exonerated? I meant to ask you about that before we got on the air.
I don't think so.
I was actually in The Exonerated years ago. It was a play written by Jessica Blank and Eric Jensen. They wrote it in 2000, and they performed it off-Broadway. It's a first-person narrative that combines the kind of black and white legal records, and it tells the story of 6 wrongfully convicted inmates, including Sonny Jacobs, Carrie Max Cook, Robert Earl Hayes, Gary Gallagher, David Keaton, and Delbert Tibbs. It's sort of a bare bones play that's put on, but it was used as a tool to get attention in the early 2000s for a lot of these cases where people weren't necessarily paying attention. And we've mentioned this recently, but I'm going to bring it up here. If you didn't have DNA, some of the early Innocence Project's cases didn't want to touch your case. And with a case like Delbert's, you have some other problems happening. It's not just the DNA. He had been traveling across the country in 1974 when this murder and rape occurred. According to the surviving victim, the assailant in her case was around 5'6" or 5'7" inches tall, with a darker complexion and a very large afro. At the time that they take the pictures of Delbert Tibbs, which you can't tell his height in the photos, Delbert is 6'3". He has a very light complexion and a very tight, small afro.
So can that height difference be a mistake? You said 5'4" and 6'3", right?
5'6" and 6'3".
Okay, 5'6" and 6'3". Okay.
It's difficult for me to imagine almost a foot being a mistake, but
Well, because you could certainly illustrate to someone visually how tall a 5'6" person is and how tall a 6'3" person is, and you would see that that's probably not going to happen.
in my opinion, so if they're hitchhiking and he picks them up in a truck and then she gets out of the truck with her back to him, I mean, there's some ways I could see a little bit of a difference. That's a pretty drastic difference.
That's what I think.
Unless somebody just doesn't know what 5'6" looks like.
Well, but that's why you would illustrate it.
Yeah. Yeah, if you put them side by side.
Seems to me like there are certain things you could remember, and the best thing to do is think about like when you're looking at somebody, because instinctively, probably with everybody you've ever met, whether you were looking them straight in the eyes, down at them, or up at them.
Yeah. They've taken 4 Polaroid pictures of him. So basically front view, left, right profile, and probably like a tall view. A full body shot. They've taken these pictures and they've sent them down to Fort Myers. Interestingly enough, Delbert Tibbs is traveling from his aunt's house and he's headed over to Memphis. He gets stopped by a Mississippi patrolman. Now remember, his family is all over Mississippi, even though his immediate family has migrated north. He has a letter that is written by these Florida officers, and it states in this letter that they gave him, Delbert Tibbs was not involved in the crimes near Fort Myers or the bolo related to it. In spite of all that, he's arrested for rape and murder.
Wait, what?
He gets a letter saying that he is not involved in the crimes near Fort Myers from the officers down in Florida. He's cleared originally because he's 6'3", light skin. The officers do not believe he's involved. But the woman, and I know her name is out there, but they kind of avoid using it.
That's fine. But, okay.
Her description is what gets him arrested. Even though he originally had a letter from them saying he wasn't involved.
Now, her identification is what gets him arrested.
That's what I'm saying. Her being able to... Her identification of him as the perpetrator is what ends up getting him arrested.
Well, sure, it's an eyewitness, right? Except nobody bothered to point out to her the fact that, perhaps she was suffering from some characteristic blindness because the other things that she attested to before seeing him don't match.
Right. And it's difficult to be that way with a witness, but it's the truth in this case that it doesn't.
Well, I feel like you could be sort of neutral, right?
Yeah.
Are you sure? Because he's definitely way taller than the guy that you thought, right?
Right.
Now, the biggest contradiction in my opinion, was the guy was initially the perpetrator that murdered the guy and attacked the woman was the man driving.
Right.
That picked up them hitchhiking.
Right.
Delbert comes into view because he's hitchhiking.
Right.
So did they just get the wires crossed?
I honestly don't know how we end up here when I look at it. I pulled an appellate document from 1976. Now, this goes up a couple of different ways. I tried to read in here the facts of the case, but there's not much to it. Here's how they lay it out. This is for September 28th of 1976. They're hearing this in the summer of 76, but this is from their ruling. It says this cause is before us on direct appeal to review the convictions of Delbert Tibbs for rape and murder in the first degree. He was sentenced to both life imprisonment and to death, respectively. But that's a nuance because Florida had a moratorium on the death penalty at the time. So it was like a backup sentence. He had been charged in a 3-count indictment with rape, the premeditated murder of a man named Terry Milroy, and the crime of felony murder for killing Terry Milroy while he was raping the other victim. So they hold a jury trial, which results in conviction for rape and first-degree murder. The jury recommends, this is an all-white jury, they recommend a death sentence by the jury for murder, so the trial judge imposes the death penalty for the murder. The relevant facts of the crime, which are brought out in this very short trial, goes like this. The victims were hitchhiking to Marathon, Florida, from St. Petersburg. They were picked up in Fort Myers by a man who it was alleged he was driving a green truck that had a rounded-off hood, black vinyl seats with no door handle, and an oil light that was blinking on and off. They get into the car, and this man drives along and then ends up driving into a field. He stops the truck and gets out of the truck with Terry Milroy, the male. He requested that Terry Milroy give him a hand with something. A minute or so pass by, and the female victim gets out of the truck, and she goes around to the back to see what's happening. And the driver was holding a gun on Terry Milroy. As he held that gun, he told the female victim to take off her clothes. He then shot Terry Milroy. He walked over to where he was laying on the ground after being shot. Terry Milroy begs that he not kill him. And the man shoots him again, inflicting a fatal wound. At this point in time, the driver proceeds to rape the female victim. He orders her to put her clothes back on and get back in the truck. So they get back in the truck and they drive back from this field to the highway. And then he tells her to get out and walk in front of the truck. And she gets out and she starts to walk to the front of the truck, but she's basically able to run and get away from this guy. That's the description that we're dealing with of this crime. So I'm just going to say up front, aside from the victim themselves, we don't have a lot of evidence here. We have a 17-year-old girl who's telling us what has happened. In terms of the appellate process, Tibbs' attorneys argue here to the court that the totality of the evidence at trial was insufficient to place him at or near the scene of this murder and rape at the time that they occurred. They were unable to establish his identity as the perpetrator beyond reasonable doubt. Specifically, Tibbs' attorneys state that there's no evidence to corroborate the testimony of the female victim. Her testimony is riddled with conflicts, so riddled, in fact, that it is inherently unreliable for this conviction and the attendant death sentence. So his attorneys feel like the conviction and the death sentence should be reversed. They also contend that no credence should have been given to the testimony of a jailhouse informant from the Lee County Jail who had been serving a life sentence for rape, to the effect that Delbert Tibbs had confessed to him about this crime. And the court, even here in their ruling, points out that this testimony appears to be the product of purely selfish considerations. So they get into the statutes related to this for the appellate process, and they say, under Section 921.141 of the Florida statutes and the Florida Appellate Rule 6.16b, it is our obligation to review a conviction for which the death sentence has been imposed to determine if the interest of justice require a new trial. Our review of the record of this proceeding leaves us with considerable doubt that Delbert Tibbs is the man who committed the crimes for which he's been convicted. Since the principal testimony against Tibbs came from the female victim, we began with the legal rules governing its reliability. So I'm just pointing this out because we have this conviction in 1974. They're hearing this in 1976, and they've already decided that there's something wrong with this case. So one of the things that's happened in the meantime, after the jury has convicted Delbert Tibbs, is the informant that they had, the jailhouse informant, he said that he fabricated his story because he was hoping for leniency in his own rape case. And while the Florida Supreme Court is going to remand this on the grounds that there's considerable doubt that Delbert Tibbs was the man who committed these crimes, I wanted to talk a little bit about how this can all happen, where we just came out of a couple of cases where we talked about fabrication from witnesses. And I wanted to know if you were okay with having a conversation about jailhouse snitches and the history of using them.
Sure.
Okay. So from the perspective of snitches, what do you think of when you think of an informant, like a typical informant?
When I think of a snitch, I think that they get stitches.
Snitches get stitches stands out. Is that what you're saying?
Yes, that's exactly what I'm saying. I think that, and I can't remember if you were the person I was having the conversation with, but there was like old sayings like thick as thieves. Mm-hmm. And then there's loyalty among thieves.
No loyalty among thieves or loyalty among thieves? No dishonor among thieves?
Well, I'm not sure. Let's see. I can't remember, but basically my point, the reason I thought of that was if you run into somebody doing the same crime you're doing, like you don't turn them in and they don't turn you in, that's what I saw and what I was looking at. But see, that would be out on the street, right?
Right.
I feel like it's every man for himself in prison, right?
Yeah.
And you literally have no leverage ever in prison. They have absolutely, no matter who you are, most of the time. If you're just, run of the mill and you happen to be, bunking with somebody who has a case that could use a nudge, right?
Right.
You could use it to your advantage, and it'd be one of the very few things and one of the very few opportunities you might have.
Yeah, it is definitely a self-serving type of situation. I pulled up this paragraph because I thought it was interesting. It says that jailhouse informants who report hearsay, so in this instance, admissions against penal interest, typically they're claiming to have heard the accused in pretrial detention having confessed or in some other way incriminated themselves. They're typically testifying in exchange for reductions in sentences or other inducements. They have become the focus of a particular type of controversy. Now, according to the Innocence Project, so take this with a grain of salt, but it is worth noting that, the Innocence Project is saying this, and it seems to me that there's some evidence to back up what I'm about to say. They have stated that 15% of all wrongful convictions later exonerated because of DNA results were accompanied by false testimony by jailhouse informants. And they say that 50% of murder convictions exonerated by DNA were accompanied by false testimony by jailhouse informants.
They seem to be sort of the bottom of the barrel for choice of what you can use at trial, right?
Yes.
I think that especially when, like in this case, the witness did identify him. However, it was starkly contrary to what she initially said. And then you have the jailhouse snitch. And so I would say that when you get to that point, and if that's about all you have, I don't think I would go there. If it's solely to bolster the case, why do you need them anyway? I mean, if you have enough otherwise. So basically, I think they're a bad idea.
Yeah, I think they're a bad idea too. And I wanted to bring up a couple of kind of famous situations where we've either talked about these or like they kind of fit into the theme of Home for the Holidays. I want to talk about them because all of these seem to have a jailhouse snitch or another involved here. This is from someone who died fairly recently. He died in 2023. Have you ever heard of Eddie Conway?
I don't know. I don't think so.
He was a leading member of the Baltimore chapter of the Black Panther Party.
Okay, yeah, no, I have heard of him.
He was convicted in 1971 for the murder of a police officer in 1970, but he ends up being released on parole in 2014. And technically, his case doesn't fit in what we're doing, but then maybe it does a little bit. So the idea was on the night of April 21st, 1970, a Baltimore police officer named Donald Sager and another Baltimore officer named Stanley Sierakowski, they were shot by three assailants who fired at least 8 rounds at the officers during their response to a domestic disturbance call. Officer Sager is killed, and Officer Sierakowski was critically wounded. About an hour later, Officers James Welsh and Roger Nolan, they arrest a couple of men near the scene of the shooting. This was based on information they had received over the police radio. The men they arrest are Jackie Powell and Jack Ivory Johnson, and they find 2 pistols near the location where these 2 guys are hiding out. The police determined that these 2 men, Jackie Powell and Jack Ivory Johnson, knew different members of the Baltimore Black Panther Party chapter. Immediately after they're in contact with these 2 men, Officer Nolan ends up briefly chasing a black man on foot. He tries to make contact with him. The man turns and fires several shots at Roger Nolan, and he escapes. Nolan stated that he had previously seen this man on his assigned beat and that he could recognize him, but he didn't know his name. So based on the affiliation of these 2 suspects with the Black Panther Party in Baltimore, Roger Nolan was shown 2 photo lineups of different party members. In the first lineup, Nolan claimed that a picture of Marshall Conway, who's known as Eddie, taken 7 years earlier in 1963, bore a strong resemblance to the shooter. In the second lineup, which used a current photograph of Eddie Conway, Nolan positively identified Eddie Conway as an individual who had shot him. According to the other officer, James Welsh, Conway was the man that he had seen Officer Nolan chasing. So the next day, Eddie Conway's at work. He works at the post office. Following an investigation where the ballistics of both shootings, according to the police, were determined to be a match, Eddie Conway is charged with the murder of Officer Sager, the attempted murder of Officer Sierakowski, and the attempted murder of Officer Roger Nolan. According to Eddie Conway, he was at work, and his supervisor and his coworkers said, he was here with us, he was at work. One of the weapons that was found with the other 2 men, Jackie Powell and Jack Ivory Johnson, was also matched through ballistics testing, allegedly. I've never seen this in person, but that's what the court documents say, to the murder of Officer Sager. So Conway goes to trial in this case. And Eddie Conway, he is represented by Charles Gary. He had asked for Charles Gary or William Kunstler to be his representative. These are 2 attorneys who were consistently representing Black Panther Party members. Both of these lawyers had offered their services free of charge, but the courts for some reason deny Conway's request, and they appoint him a lawyer who performed no pretrial investigation and never met with Eddie Conway. Eddie Conway doesn't want much to do with the January 1971 trial for these murders and attempted murders. Now, Jack Ivory Johnson, he had confessed to the police, but he names Jackie Powell and Eddie Conway as the one who shot Officers Sager and Sierakowski. According to court testimony, Jack Ivory Johnson stated that he had fired into the air because I did not have the heart to, quote, kill the pig. But later, Jack Ivory Johnson refused to testify against Eddie Conway, and he claimed that his statement was coerced. So the state's case is largely based on photo identification by Officer Nolan at this point. If they're not going to have testimony from Jack Ivory Johnson, they need to do something else with it. And what do they do to bolster their case, as you say? They find him a jailhouse informant. So the state calls a guy named Charles Reynolds. He testifies that while he was sharing a cell with Eddie Conway before the trial, Eddie Conway, for some reason, had confessed to him. But Eddie Conway had actually protested when Charles Reynolds got placed in his cell because Charles Reynolds was a known informant. One of the points that the prosecution argued proved the truthfulness of Reynolds was that Reynolds said Conway had told him that he had taken Officer Sierakowski's watch, a fact that was not released by police during the investigation. Finally, the ballistic evidence connecting the weapons to the murders also plays a role in the trial. The jury hears all of this evidence, and they convict Conway of this murder. So he and Jackie Powell are sentenced to life in prison. They both appeal, they go through the whole process. But I wanted to point out, we have this informant here where something interesting has happened. He comes up with a piece of information that has not been released to the public.
Right, but the police had it all along.
Right. So I was going to ask you, I know we're talking about Delbert Tibbs and now Eddie Conway. What do you think about it when the police give information to assist with a jailhouse informant getting a more detailed confession?
Well, that gets a little more complicated.
Right.
Because if nobody has the information, but then the snitch has the information, if the cops didn't give it to him and the person who they're testifying against isn't guilty, who gave it to him?
Right.
Right. Okay. So I don't think that only the killer could know information. I don't think it's as relevant as it once was.
Yeah, I think DNA and constant technology has kind of...
I think holdbacks are dumb to some extent, especially in this type of situation where clearly, as everything rolls out, they had to have given the guy the information, right?
Yeah.
And it's dishonest. And I think that if I sat on a jury, I would ignore any jailhouse snitch testimony.
Yeah.
And I think I would encourage others to do the same. Because a lot of times I would actually say, especially a jailhouse snitch, that the perpetrator told them something that the public didn't know. At one point in time, I did this little study. It wasn't a big deal. And it was just me being curious. A lot of things that come up as never before released are not never before released. You can typically find them somewhere in the media.
Yes. Well, today you can definitely find a lot of stuff today in social media.
Well, but you also don't hear the never before, only the murderer would know this information. You don't hear that as much now. I don't think. But I'm just saying that even in old style cases where, he had to have done it because nobody else knew this. Well, a lot of times you can go back and you can find where it was known, perhaps not widely known. Perhaps it's a genuine proclamation that, nobody knew this detail with regard to the investigator saying it, but you can still nonetheless go find it.
Right. Well, one of the other big jailhouse informant cases for me is one of the saddest cases. I don't think we've ever covered it on here, but I'm sure you're familiar with it. That's the case of Cameron Todd Willingham. Do you know that case, or can I describe it for you and tell me if you know about it?
Sure.
On December 23rd, 1991, a fire destroyed the family home of Cameron Todd Willingham in Corsicana, Texas. In the process of that fire, it killed his three daughters, 2-year-old Amber Willingham and 1-year-old twins Carmen and Cameron Willingham. Willingham escaped the home with only minor burns. Stacy Kuykendall, who was, at the time, she was Cameron Todd Willingham's wife and the mother of the three daughters. She wasn't at home. She was out at a local thrift shop, and according to her, she was shopping for Christmas presents. Prosecutors ended up charging Cameron Todd Willingham as having set that fire and killed the children in an attempt to cover up him abusing his wife and kids. But there was no overall evidence of child abuse, and Stacy, his wife, she told prosecutors that he had never abused the children. The kids were spoiled rotten, and she had insisted that he would never harm the children. But she did say that she had been abused by him. There's some questionable evidence in that case. One of the big things was after the fire, the police investigation had determined that the fire had probably been started using a form of liquid accelerant. This evidence was based on char pattern findings in the floor that looked like they were in the shape of puddles. And basically, it was used by one of the investigators to say that there were multiple starting points of the fire, and that there was a finding that the fire had burned very fast and hot. So this all was used to considered to indicate that the fire had been ignited with the help of a liquid accelerant of some kind. The investigators at the time also found charring under the aluminum front door jamb, which they believed was a further indication of some type of liquid accelerant. They had found some positive tests for accelerant in the area of the front door, but there was never a real motive found, and Willingham's wife said that the couple had not been fighting at the time. One of the people involved in getting to that execution was a man named Johnny Webb. So we have this arson evidence that's presented at trial against Cameron Todd Willingham, and we also have a jailhouse informant. His testimony was contentious for a number of reasons, but Johnny Webb claimed that Cameron Todd Willingham had come to him and confessed that he set the fire to hide an injury or maybe the death of one of the girls. And according to this story he weaves, it was Stacy, his wife, who had caused this injury or death. But none of the girls at the time of their death were found to have had physical injuries that were still distinguishable after the effects of the fire. Now, Johnny Webb talks to a reporter for The New Yorker that maybe he got it wrong. He said he had been prescribed a lot of medication at that point, was being treated for bipolar disorder. But at Willingham's trial, he offered up what could be considered an explanation for the individual distinguishable burns that were found on one of the girls' forehead and arms. I don't remember which girl it was right this second. I don't think it was the twins. I think it was the older girl. But he said that Cameron Todd Willingham had confessed to burning her with a piece of wadded up paper in an effort to make it appear as though the children were, quote, playing with fire. The prosecutor on that case is a guy named John Jackson, and he noted that Johnny Webb was considered unreliable, but after all this goes down, he supported an early prison release for Johnny Webb. Johnny Webb sent a motion to recant his testimony to prosecutor John Jackson, which declared in his handwriting, Mr. Willingham is innocent of all charges. So Cameron Todd Willingham's attorneys were not notified. And then later on, we don't know why, but I'm guessing there was some pressure put on him, Johnny Webb recants his recantation. When he's talking to this reporter and at other times, he asks questions that were like, has the statute of limitations run out on perjury? Either way, Johnny Webb and, for his part, John Jackson, the prosecutor, they denied that Johnny Webb was offered a sentence reduction in return for his testimony against Cameron Todd Willingham, which you have to tell the jury in the court if you have made some kind of deal. Evidence of this deal would have meant that Johnny Webb should not have been testifying and would have eliminated it. There is a handwritten note that's discovered by the New York Times in February 2014, which is years after Cameron Todd Willingham's execution in February of 2004, 10 years later. and it indicated that they did make a deal between the prosecutor's office and Johnny Webb. All of this is to say that jailhouse snitches or jailhouse informants can lead to terrible consequences if they're taken seriously.
And just to be clear, Cameron Todd Willingham was executed and he has never been exonerated.
Correct. That's why he is not one of the people that we talk about in Home for the Holidays, but I did find an opportunity to bring him up, and I sort of use an in-run to do so because his case is important. And if nothing else, no matter where you fall, it should warn us that bunk science can lead to terrible consequences.
I don't really know much about that case. It was a little bit before my time in true crime.
The Texas Forensic Science Commission, at some point in the 2009 range, they sat down and they started looking at it from the perspective of putting a panel together. They get as far as the flawed science. If you go and look at it from the perspective of determining what had really happened, they don't do as much there because they sort of end up saying, what are we supposed to do with the investigators that found for this and the people involved here? They never really get around to hearing it from the perspective of actual innocence or not. The trial, as it rolls out, they offer him, this is back in the early 90s, they offer him life in prison. He says, no, I didn't do it. The investigator that testified said that there were 3 points of origin and that it had to have been a fire set by human hands. There was burned material that, according to the prosecution, had tested positive for either witch hazel or mineral spirits. And the interpretation of that by the investigators was that there had been some kind of lighter fluid or something being used as lighter fluid. They said that he escaped the house with bare feet and no burn marks. This is the prosecution's case, by the way, not, this is what they're presenting. So this was, in their opinion, evidence that the accelerant had been poured by him as he ran out of the house. They have multiple witnesses they present, and then they bring in the jailhouse informant. So in 2009, the prosecutor admits that Cameron Todd Willingham had burns, but he said that they were so superficial that they suggested to him that maybe he had just self-inflicted them on the way out in an attempt to divert suspicion from himself. Fire investigators who reviewed the case told David Grann, the reporter for the New York Times, that Willingham's he has first degree and second degree burns, and they were consistent with being in a fire the moment before everything suddenly ignites in the room. According to John Jackson, the condition of the house was any escape or rescue route from the burning house was blocked by a refrigerator up against the back door. Any person attempting to escape or run through it couldn't get out. There were 2 refrigerators in the Willingham house. They were both sitting in or next to doorways. Now, according to Jimmy Hensley, who was a police detective, and this guy Douglas Fogg, who's the assistant fire chief, they investigated this fire, and they told David Grann they never believed that the refrigerator was put in the doorway, like John Jackson said, to be part of an arson plot where no one can escape from this. And particularly with Douglas Fogg, he said it didn't have anything to do with it. Now, according to Cameron Todd Willingham's interview, he claimed that when he got to Navarro Regional Hospital, they had checked him for smoke inhalation. And Jackson says that Cameron Todd Willingham never inhaled any smoke. But Willingham's statement, meaning Cameron Todd Willingham's story to police, and multiple eyewitness accounts detailed him trying to get back into the house and around the fire. And he was the one who ended up being blocked by the refrigerators that were in the weird doorway setup. So the one problem I have with this case is Cameron Todd Willingham was offered the opportunity to eliminate himself as a suspect by taking a polygraph. His counsel said, don't do it. And his counsel also told him that he should take the life sentence and plead guilty. But he insisted that he would not admit to something that he hadn't done. when it comes to trial time, he does not testify. The defense only calls one witness. They call the babysitter, and the babysitter gets up there and says she does not believe it was possible for Cameron Todd Willingham to have killed his. This case never really comes back around on appeal. It's denied, no matter what anybody says. And it gets attention again in December 2004, where people start talking about what was going on with it. The problem is he had already been executed. What we hear about from the New Yorker, it doesn't come out until 2009. The documentaries don't start coming out, which the first one I watched was Incendiary. That came out in 2011. The rest are like one-offs of other episodes. But I as far as like, is he innocent or guilty? I fall on the side of he's innocent. Like, I think there was an accidental fire in a house that wasn't, going to respond well to fire. And that's how everybody dies.
So I think that maybe that's the linchpin point, because like in other exoneration cases that we've done, somebody was murdered and they were murdered, right? Yeah. And that means somebody murdered them. Right. And so that means there's another guilty party out there. I don't think there was ever any sort of implication that in the event he was not responsible for the fire, that someone else had set it, right?
Right.
Okay. And that makes it more difficult because you're literally looking at a situation where a fire happened and 3 small children died, or a man set a fire and killed his 3 small children.
Right.
So it varies from like a typical egregious violent murder that you just have the wrong person. You end up in a situation where you have to, it would make it twice as bad for it to literally be some sort of accidental fire.
Yeah. The problem with this case was at every turn there was a contradiction. And it seemed like for a period of time from about 2005 to maybe 2011, it was like everybody was out to make money on him having been innocent or not.
It's a big deal.
It was a huge deal.
I don't know that much about this case. I mean, it happened in the early 90s.
Yeah, it was a long time ago. Like I know all about it from the perspective of after he was even dead.
Well, one of the interesting things to me was they did present that it was junk science, right? The arson. And I took issue with what I do know about that because, fine, there's no evidence of arson. You have used a junk theory to say that this is arson.
Right.
What was the cause of the fire? Because the absence of a cause of a fire, it lends towards arson, right? Because there's only so many places in a house that are going to catch on fire.
I agree with you. So I kind of derailed everything from Delbert Tibbs for a minute, and we talked about Cameron Todd Willingham. For Delbert Tibbs' part, do we want to go back to him for a second?
Sure.
Delbert Tibbs, he is an interesting exoneration. You can read about him at Northwestern School of Law. He becomes a writer and an anti-death penalty activist after having this experience. He's indicted and convicted in 1975. He ends up being released pretty quickly. By 1977, he's out of jail. And it takes about 5 years for the Florida State Attorney to dismiss all of the charges, saying they're not going to have a retrial. But based on the documents I was reading early in this episode, the Florida Supreme Court had reversed the decision related to his conviction and death sentence and sent it back down to the lower courts. They had considerable doubt that Delbert Tibbs was the man who committed these crimes. He did ultimately spend several years in prison because of this, and he was released in January of 1977. So after that time, he started campaigning for changes in the criminal justice system, especially limits on the use of eyewitness identifications. And since then, he was totally right. Numerous studies have shown that eyewitness identifications are unreliable and highly flawed. He was also against the concept of a jailhouse informant. He was among the audience when Governor George Ryan of Illinois and other politicians watched the play that I mentioned early on, The Exonerated.
In this case in particular, some of the things that baffle me, okay, so if he picks him up in a truck, whose truck was it?
Right.
How was he driving it? Those are things that I feel like should have come up in trial, right?
I would say, yeah.
If he was somebody that like was at least hitchhiking, possibly transient in nature, he was visiting, he lived elsewhere, he'd come back. There's all kinds of stuff here that point away from him that I feel like just gets skipped over.
Oh, it does. I was just going to point out that when George Ryan left office, he commuted the death sentences of 167 inmates from death to life imprisonment, largely because of cases like Delbert Tibbs. But the other thing that bothered me about this, and I know you're saying like there's these holes in this trial and he gets a death sentence based on almost nothing. Why didn't they plug the holes? Like, where's the truck, etc. My problem was, at the end of the day, this guy who shot and killed Terry and raped the woman that was with him, he just walked away.
All right.
That's more disturbing than like anything I can think of. That he just literally is out there living his life, or maybe he got convicted for something else or did something else stupid, but ultimately someone almost was executed. The perpetrator's green truck was never found, according to... I did pull that up because I wanted to try and answer your question with this. If people want reading, there's this thing called the Florida Commission on Capital Cases. Their 2002 edition by Locke Burt, the chairman. He wrote a case histories, which is a review of 24 individuals released from death row. Delbert Tibbs is the first page of that, although it's part of something else. So if you find it, it's on the Supreme Court, like the U.S. Supreme Court's website. It'll say like 135 for like the first pages, but they talk about Delbert Tibbs' case, and it doesn't have a lot to say about it. But one of the things they do point out is that the Florida Supreme Court noted a Florida law which dictates that no corroborative evidence is required in a rape case where the victim can testify directly to the crime and identify the perpetrator. The same law, however, requires extreme scrutiny of the victim's testimony if she is the only witness with the prosecution.
Not to mention, that's not geared towards a stranger rape.
Correct. You're 100% right. That is meant to deal with other scenarios of sexual assault and rape.
There's two options here for me, and this is terrible for me to say. I don't think we've named the female.
I'm not going to name her now, no.
Okay, well then I'm going to say this, and it's nothing against her. Okay, it's just what comes to my mind. Either she suffers from, like in this case, it would be like racial blindness, which is where she just said, oh, he's a black guy. Sure, it's him, right? And genuinely...
Well, cross-racial, yeah, go ahead.
Well, maybe it's called something else, but she just genuinely saw him and thought, yes, that's him. Or there's more to the story and she needs a perpetrator, just sort of like some of the other cases that we've covered where they automatically say, yeah, that's him.
Well,
even though it doesn't corroborate what they've said previously, or the crime is made up, or whatever the case may be, right?
Well, it could be that, you're indicating that there's the potential that the companion that we have not named for a reason killed Terry Milroy?
I would say not because of anything that I know about this case personally, like what actually happened, but the fact that the perpetrator was never caught and she jumped right on maybe the first person they presented as a possible suspect, even though he didn't look anything like what she described.
Right. I would agree with that. And that,
in my opinion, that's one of the very first indications that there's a problem with the victim witness, right?
Okay, so to follow up with what you're saying, there are 5 things they include here that back you up 100%. And I think he was trying to not say that thing. This is what it says. First, there's no other evidence besides the victim's testimony placing Delbert Tibbs anywhere near Fort Myers at the time of the crimes. In fact, the evidence leans the other way. Tibbs' presence had been established by police in Daytona Beach on February 2nd and 3rd.
Right, hence the letter.
He was also known to have been in Leesburg, Florida on February the 6th, Ocala, Florida on February the 7th. So, like, he has varying alibis that aren't, if you're just trust me. If you got 6 cities that are verifying where you are and you got receipts and people remember you, you weren't somewhere else. Second, the perpetrator's green truck is never found, even with all the details that the victim provides the police an hour after the attack. A car and helicopter search of the area never produced a vehicle like it. So they're going from the perspective of, if this was something that Delbert Tibbs abandoned, we would find it. Third, Delbert Tibbs was never found with a gun or car keys in his possession, nor was a gun ever found, which maybe we can get over that. Fourth, police stopped Delbert Tibbs on 3 separate documented occasions based on the victim's description of the perpetrator. He cooperated with the police every single time, and there was never any evidence to cast doubt on his credibility. And the last thing they include here is, fifth, since the crime occurred late at night and the victim had been smoking a significant amount of marijuana all day, her ability to accurately identify her attacker would be seriously diminished. So he's politely saying, without saying, maybe she's just wrong, or maybe something else is going on here.
No, I mean, she could be wrong, okay? Yeah. But it's a pretty serious situation for her to just be wrong, especially under the circumstances presented.
Yeah.
It is possible that she genuinely felt like she had identified the correct person. It's also possible that she knew without a doubt she had not identified the correct person and never would.
Well, there were multiple people that spoke out along the way afterwards that they feel like his conviction was just. So if you go reading the stuff that I'm talking about, you'll find this buried, but it is there.
What? They were against his exoneration?
Yeah, that's one of the reasons this case gets in the pile. But there's not a lot to it. But Raymond Markey, who was out of the Attorney General's office, he said Tibbs' alibi that he was in Daytona Beach continuously during the time the crime was committed was impeached by the receipt from a Salvation Army store that Tibbs had stayed in Orlando the night prior to the murder. The record also demonstrated that the victim's testimony was corroborated by an inmate who was in a cell with Tibbs, who testified that Tibbs' case,
which has been thrown out.
Right. He said Tibbs' case had racial overtones to it. Several South Florida politicians had written letters to the AG wanting us to confess error in the case because Tibbs is some kind of prominent black minister in Chicago. It had generated complaints from black organizations. That was their standard operating procedure. As an aside, I will never forget reading the record, particularly the testimony of the victim, which carried with its own credibility. Defense counsel suggested that she was lying because her own boyfriend had raped her and she was blaming Tibbs. She responded, "You have to be kidding. I've been raped so many times by men that I feel like a pincushion. If this was only a rape case, I wouldn't even been here, but he murdered my boyfriend." I called the prosecutor and asked if that testimony was as powerful as it sounded. He told me that all of the jurors looked at Tibbs, and as far as he was concerned, the moment she said that, the case was over. The Tibbs case was the most outrageous example of judicial corruption I ever experienced in 25 years that I spent in the Florida Attorney General's office as a criminal appellate attorney. I lost all respect for the judges who participated in the majority opinion clearing him. I would love to know from behind the scenes the story of this one, but like Joe D'Alessandro, Tibbs was not innocent of the rape and murder. He was the unworthy recipient of intellectually dishonest judicial office.
That's amazing to me.
I hate to end on a note like that, but I don't think I can top that. That guy saying those things and not seeing the forest for the trees. Am I supposed to be convinced and think that something's going on there? Because that's not what happens. I just think that guy's probably a really mean racist and a terrible attorney.
Well, right, and blind to the because you've got to respect the process either way, right?
Yeah.
The exonerations, the convictions, you've got to have some respect for it.
Yeah.
Special consideration was given to True Crime Excess by LabrottieCreations.com. If you have a moment in your favorite app, please go on and give us a review or a 5-star rating. It helps us get noticed in the crowd. This is True Crime XS. True Crime Excess is brought to you by John and Meg. It's written, produced, edited, and posted by John and Meg. You can always support True Crime Excess through patreon.com, or if you have a story you'd like them to cover, you can reach them at truecrimeaccess.com. Thank you for joining us.
This is just a reminder that we are part of the Zencastr Creator Network, and I put a link in the show notes if you guys want to check it out for your own podcasting needs. I've always enjoyed using Zencastr. Their quality is great, and we were able to join their Creator Network at kind of a key time in their history. I have enjoyed it. I've considered a lot of other places to record and a lot of other ways to put together and host and distribute our podcast. But I've stuck with Zencastr the longest. We've been with them for hundreds of episodes now. And I'm putting a link in the show notes where you can check out what they have to offer and see if it's something you would want to use.